just to set the stage, remember that we gave the report to Bill Barr and his senior staff at the end of March of 2019. And then in 2 days, Bill Barr issued his alleged summary where he concluded that that we had decided not to make a recommendation with respect to whether the president had committed obstruction, and thus left it to Bill Barr to make that conclusion. And his letter said that we hadn't found any crimes and that he, the Attorney General, concluded that there was no obstruction. This memo, as you said, is a doozy because it has been kept under wraps, and the Department of Justice fought even giving it to the district court for her to read. There is a reason when she read it that her decision was that this needs to be made public. The Court of Appeals agreed with her. Now to the substance. Why did they try and keep this under wraps? There is a sentence in here that is astounding to me. The two senior staff say to Bill Barr that the reason he should make the decision is because if the memo comes out, it might be read to imply that the president committed obstruction. Let me just repeat that the reason Bill Barr needs to say something is because if the report comes out, it could be read to say that the president committed obstruction. So what is really noticeable is there is no discussion in this memorandum about Bill Barr simply telling the special counsel, you know what, I want you to conclude whether he committed obstruction or not. And the reason that Bill Barr, we now know clearly from this memo, did not send it back to Mueller, who reported to him, was because he knew exactly what the answer would be, because it says in black and white that this memo could be read to conclude that the president committed obstruction. And then there's a legal point that's just also dead wrong. They say that the president essentially didn't commit obstruction because there's no precedent for finding that somebody commits obstruction unless they're also guilty of the underlying crime for which they obstructed. That is legally wrong. Our report actually addresses that. We cite all sorts of cases, including the Arthur Anderson case, which I know very well. And this memo simply does not successfully, in my view, address those legal precedent. And it's just simply not the case that you can't be guilty of obstruction if you didn't commit the underlying crime. And then, and just to bear with me, the final point is the memo really gets the Mueller report wrong because they seem to think that we found that there was no evidence of the underlying crime, meaning conspiracy with the Russians. That's not what our report said. It said that there's evidence. It's just that we didn't think there was evidence beyond a reasonable doubt. So the sort of upshot, Nicole, is I can understand why the department fought long and hard not to have this see the light of day. And it's actually quite a shocking document.
I want to stay with you, Andrew Weissmann. I found some of this language, and I want you to take me back and do your best to explain why Ed O'Callaghan and Steve Engel thought they had to answer a question that Robert Mueller decided not to answer. They write this in the second page of the memo used by Bill Barr. Although the special counsel has declined to reach a conclusion, we think that the department should reach a judgment on this matter. Under traditional principles of prosecution, the department either brings charges or it does not. Because the department brings charges against an individual only where the admissible evidence would support the proof of such charges beyond a reasonable doubt, any uncertainty concerning the facts or the law underlying a proposed prosecution ultimately must be resolved in favor of that individual. The principle does not change simply because the subject of the investigation is the president. That's not what the special counsel found at all. They found all the evidence and the nexus to the act for 6 acts of criminal obstruction of justice. What Robert Mueller said was that if I could say that laws hadn't been broken, I would, which is Mueller's way of saying laws were broken. Why did they distort the basic fact of Volume 2 of the Mueller probe report?
So, Robert Mueller acted out of principle. Whether you agree with it or not, his view was because the Department of Justice had a policy that he was bound to follow, that you could not indict a sitting president. He thought it was unfair to say that that person committed a crime because they would not have their day in court to vindicate themselves. There might be an impeachment. There might later be a prosecution for obstruction. But that was, as the report lays out, Robert Mueller's principled thinking. As I said, whether you agree with it or not, it was, of course, within the discretion of the Attorney General to say, you know what, Bob, I disagree with you. You need to come to a conclusion. I actually think that's wrong. This memo makes it clear that the reason that Bill Barr did not ask Robert Mueller to simply come to a conclusion is because, as it says here, the report can be read to find that indeed he did commit obstruction. As you said, Nicole, Robert Mueller's way of saying that but not saying it was to say, okay, in volume 1, dealing with the underlying conspiracy, we conclude that there's not proof beyond a reasonable doubt. But in volume 2, we're going to essentially defer. We're not going to reach a conclusion, and don't take that as saying that in any way we are absolving the president of obstruction. So this was just Bill Barr clearly just taking advantage of and playing Robert Mueller. And just to put a fine point on it, you know, as I've said in the past and as public knowledge, Bill Barr was a personal friend of Robert Mueller. So it's particularly egregious that he simply wouldn't have said to Robert Mueller, why don't you reach a conclusion, since I think it's important to do that. And it's notable that Ed O'Callaghan and Steve Engel do not address that at all. That silence speaks volumes. Why didn't they ask Robert Mueller to simply reach a conclusion? Because they didn't want the answer. That's why.
Andrew, for our viewers, who are Ed O'Callaghan and Stephen Engel?
Yeah, so Stephen Engel was the head of the Office of Legal Counsel. That is an extremely important position in the Department of Justice. They essentially decide the law for the purposes of all of the federal government. I mean, when they pronounce that you can or cannot do something, that is abided by, absent the president, you know, saying that he's not going to follow it. But for anyone who's an underling, you follow what the Office of Legal Counsel says. So that's a very, very senior position. And then Ed O'Callaghan was the number 2, called the PAYDAG. Only DOJ has those kind of crazy acronyms. But that is the number 2 to the Deputy Attorney General. And so he reported to Rod Rosenstein at the time. So again, 2 very, very senior people. And it's notable, given that we dealt with Ed O'Callaghan almost on a daily basis, that at no point did he or Steve Engel or Bill Barr say, we want you to make this decision. And this memo makes it very clear why. I would like to have been a fly on the wall when Amy Berman Jackson, who's the district court judge who insisted on seeing this and got it over the objection of the DOJ law and prosecutors. I could just like to be a fly on the wall when she read what was here. So quite an unusual document.
This calls for you to speculate, Andrew Weissmann, but you have a pretty informed perch from which to do so. Do you believe these 2 men, knowing what they knew of the evidence, that, I mean, Ed, I think, met weekly or every other week with one of Robert Mueller's deputies, right? He knew everything that was happening. He knew the evidence being developed. I think he knew the witnesses that were in until the last Don McGahn interview and the second report comes out in March. I think Mr. Goldstein was trying to pursue phone records to bolster some of the obstruction incidents reported out, the tampering with witnesses and the threats to fire Robert Mueller. What do you think? Do you think he wrote this memo with Steve Engel on his own volition, or do you think Bill Barr asked for it?
I don't know the answer to that, Nicole. There's no question that the conclusion is certainly one that I think that all 3 gentlemen knew exactly what they were going to conclude. As I said, if they were really looking at this objectively and not trying to come to a certain conclusion, they would have simply just asked the special counsel to do it. Remember, that was the whole reason for having a special counsel, was the idea that this needed to be removed from the sort of political people in the Department of Justice, all of whom, by the way, Barr, Engel, and Ed O'Callaghan are political appointees. So that was the whole reason to have a special counsel, and they should have just sent it back to Robert Mueller, and it's noticeable that they did not. What their individual motives are a little unclear to me, but I think that the conclusion is clear as to what they were going to reach. Even just reading this again on a cursory level, it also reads very much that everything is skewed from a sort of defense perspective. And what do I mean by that? When you're on the defense side, you try and separate each piece of evidence, and you don't try and look at it holistically to say, when you're the government, you say, what are the odds of all of that evidence being true, that this happened and this happened and this happened, and all of that has an innocent explanation. So here the memo just separates each and every instance and doesn't look at the whole panoply of evidence of the president's obstructive conduct. And I have to say, I think the weakest part of this memo is, in addition to the legal point I made, is you remember the Don McGahn evidence where he was instructed by President Trump to create a false memo that said that he, in fact, the president, never ordered that Robert Mueller be fired. And Don McGahn said that. And if you look at this memo, it says, well, it's really unclear what the evidence is. Well, Don McGahn was going to resign from his position as White House counsel. You don't do that if you believe that the evidence is ambiguous.